petitioner was invalid for being predicated on matters sub judice. Those who are pure Latin speakers will call it sub judice.
Yes.
The third issue is whether the impeachment of the petitioner was invalid for being conducted in contravention of the petitioner's right to fair hearing.
Yes.
The fourth issue is whether the provisions of section 33, subsection 8 of the County Governments Act contravene Article 50, Clause 2, Paragraph O of the Constitution of Kenya, and hence is unconstitutional. 50, Clause 2, Paragraph O. Unconstitutional, yes. The fifth issue is whether the threshold for the impeachment of the petitioner was in fact met.
Yes.
And the sixth issue is whether the impeachment process was in compliance with the established principles of public participation under Article 10 of the Constitution.
Yes.
Was in contempt or defiance of an order of court, and I'll also be submitting on the consequences of that.
Yes.
My Lord, my late Professor Okoto Gendo used to tell me that there had been no issue of law without an issue of fact. Let me begin by raising the factual issues. When you look at volume 1B of the petitioner's document,
yes,
you will find Annex BKM2 to the supplementary affidavit,
yes,
sworn on 4th September 2024 by the petitioner.
yes,
At page 369 of that affidavit is a letter dated 9th August 2024
yes,
from Mutuma Gishuru and Associates Advocates
yes,
to the Speaker of the Senate and to the Clerk of the Senate.
yes,
On the face of that letter, you will see receiving stamps by both offices confirming receipt of that letter.
yes,
That letter conveyed to the two offices a ruling by Lord Justice Kassan,
yes,
delivered at Meru High Court on 24th July 2024.
yes,
At page 4 of that ruling, which is available at page 374 of the volume,
yes,
the court ruled, and I quote, "The upshot of the above is that the impeachment process is halted pending my ruling."
yes,
The upshot of the above is that the impeachment process is halted pending my ruling, and since this is a matter of public interest, the rulings will be delivered on Monday, the 29th of July, 2024.
Yes.
At page 376
Yes.
of that volume is an order of the court dated 29th July 2024,
Yes.
deferring the ruling to the 20th of August 2024.
Deferring the ruling to?
20th August 2024.
Yes.
It is crucial to keep our eyes constantly fixed on the fact that the impeachment process had been halted pending the ruling.
Yes.
It is during the subsistence of this clear and unambiguous order
Yes.
that the County Assembly of Meru passed the impeachment motion
Yes.
against the petitioner.
Yes.
Allow me to draw the court then to the next factual matter, progressing with that.
Yes.
At volume number 5,
Yes.
of the petitioner's documents,
Yes.
the court will find annexure KM8
Yes.
to the supporting affidavit of the amended petition sworn on 23rd December 2024.
Yes.
And from page 1398,
Yes.
the court will see all the documents that were filed by the petitioner to the Senate. In fact, let me just put it this way. The entire Annex KM8 are all the documents that were filed by the petitioner before the Senate.
Yes.
Then the court will look at page 1399
Yes.
of volume 5. That is the document called Response of the Governor to the Impeachment Motion.
Yes.
At paragraph 2 of the governor's response on that page, 1399,
Yes.
the governor explicitly draws the attention of the Senate to the order of the High Court of Meru, that the orders of the High Court of Meru of 24th July 2024 and 29th July 2024. The governor explicitly draws the attention of the senators.
Yes.
At page 1414 of volume 5 is the affidavit of the governor before the Senate. Page 1414 is the affidavit of the governor before the Senate.
Yes.
At paragraph 6 of that affidavit,
Just a moment. That's paragraph 6.
of that affidavit, which was sworn on 16th August 2024,
Yes.
the governor draws the attention of the Senate to the orders of the High Court at Meru of 24th July 2024 and 29th July 2024.
Yes.
And annexes those orders as exhibits.
Yes.
Then we go to volume number 1A of the governor's documents. Volume number 1A of the governor's documents, you'll come across exhibit BMK 1D.
1D?
1D for dog.
Yes.
Exhibit BMK 1D is a Hansard, rather the Hansard of the afternoon sitting of the Senate
Yes.
of 20th August 2024. The Hansard of the afternoon sitting of the Senate of 20th August 2024.
Yes.
In that volume, that Hansard starts at page 223.
Yes.
If you go to page 343, which is a continuation of that Hansard,
Yes.
you will find a part of the submission of counsel for the governor, coincidentally yours truly, my lord.
Yes. Just a moment. Yes.
It starts, the material part for purposes of this submission, it starts at paragraph 6 of that page, which starts with the words finally. My lord, I only want you to write verbatim these words because there are many. I'm going to read them, but I'll give you the effect of the words I'm about to read.
Yes.
For the governor, it was submitted, and I quote, that finally, Madam Temporary Speaker, sir, the impeachment process itself, in its entirety, I wish to refer you to volume 2 of the governor's documents at page 28 to 32. On page 28, you can see Meru Constitutional Petition number E013 of 2024. The parties to that case are Honorable KWINGWA MWANGAZA, the petitioner, and the County Assembly of Meru, the respondent. The two parties now appearing before you and represented by counsel, as has been the case. If we turn to page 31 of the governor's volume 2, there is a ruling of court. The ruling of the court says, the upshot of the above is that the impeachment process is halted pending my ruling. Since this matter is of public interest, the ruling of the interested parties and the main petition will be delivered on 29th July 2024 via email. It is in the public domain that that ruling was not delivered on that day and is still pending delivery, and this order remains in force. As a matter of principle, I invite senators to reflect on this question because the governor has been brought here by the county assembly claiming that it wants to strike a blow for the rule of law. And yet, we are here debating this matter in the face of an order of court reading, and I quote, the upshot of the above is that the impeachment process is halted. As a matter of principle, distinguished senators, what position do you want to take on this matter? You are the judges. You will make the decision one way or the other. I have done my part as a legal representative to my clients. I have made full and candid disclosure that we may be perpetuating a violation of the rule of law. I am not the decision maker. I leave the eventual decision to your able hands, distinguished senators. Is this the way we shall grow our institutions? If a court of competent jurisdiction can make an order such as this, and the county assembly proceeds in violation of this order, the governor has told you, on her part, she has taken some action on this violation, and from page 35 onwards, you will see a contempt of court application that has been filed. She has done her part. The court will deal with that. Shall we, sitting here in good conscience and our attention having been drawn to these facts, perpetuate this process, which on the face of it, the county government has undertaken in violation of a valid court order? It is not for the governor, it is not for her council to make that decision. Distinguished senators, the heavier task lies with you to make a decision one way or the other on this question of principle, touching on those specific paragraphs of those specific counts that I've alluded to, and to this impeachment process as a whole, as I have drawn your attention to page 30 of volume 2 of the governor's documents. The point I'm making is this. The Senate's own document, the Hansard, confirms that the governor's council drew the Senate's attention to the fact that the impeachment process was proceeding in violation of an order of court.
Yes.
That is not enough, my lord. At page 353 of that volume, again,
Yes.
the last paragraph, you will see the contribution by Senator Dr. Halwani. The very last paragraph or entry on that page 353. It says, "Thank you, Mr. Speaker, sir. I am reflecting on the history of Parliament. If Martin Shukuku, Jean-Marie Seroney, Chelagat Mutai, and J.M. Kariuki were alive, would they have wanted that the chair settles the important issue of the matters in this case that are currently active in court because they are sub judice?" I will revisit the question of judice later, but one of the questions that were active before court was this petition at Meru, in respect of which a valid order of court had been issued. My lord, it is in the face of this order in Meru, it is in the face of these filings by the governor, it is in the face of these submissions of counsel for the governor, drawing the Senate's attention to the fact that it was progressing with a process in violation of the court order, that the challenged impeachment motion before you, or the challenged impeachment resolution before you, was reached.
Just for clarity.
Yes.
Please go back to that page 354.
Yes.
The respondent states, rules that contribution is out of order.
Correct. That's part of the violation of the process, because the respondent is trying to block his attention from being drawn to relevant matters. Think about it, my lord. Think about it.
Yes.
How can it be out of order for a decision maker like you sitting here to be drawn to the fact that you are breaching the law? If any counsel here were to stand in the midst of these submissions of mine and say, my lord, we are progressing in violation of the law, wouldn't you, in good conscience, sit down? Let us first of all assess the substance of that submission, because that is important. Rule of law is crucial. So that ruling that was out of order is a perpetuation of the determination of the respondent to proceed in violation of the existing order of court.
Proceed.
Thank you. So, my lord, we then take you to volume 10 of the petitioner's documents, and I would invite you to read in its entirety the decision running from page 109 of volume 10
Yes.
to page 118. But I will request that in reading that volume, you pay special attention to paragraphs 33 to paragraph 40 of that ruling. I wouldn't want the court again to regurgitate it, but I will read it for its full tenor from my end.
Yes.
This now is the ruling of the High Court at Meru on the contempt of court application that the petitioner before you filed.
What did it state?
The ruling is, we used to call it hot from the printing press. It's dated 13th of February 2025, barely 8 days ago.
So, Councilor, I will stop your time.
Thank you.
Because we need to discuss that ruling.
Yes, ma'am.
To the limited extent. And
Yes.
I will give the respondents and any of the interested parties an ability to chip in.
Yes.
There's only one High Court in Kenya. We have stations, Meru and MILIMANI.
Yes.
When you cite that,
Yes.
it's a finding of this court.
Correct.
So we cannot proceed as though I am reviewing it,
Correct.
having a merit discussion of it.
Correct.
That is your position.
That's my position.
Anyone for the respondents or interested parties who takes a contrary view? That for better or for worse, so let me explain. For better or for worse, that ruling delivered by the High Court sitting at Meru, dated 13th February 2025, is the same as a ruling of this court. I cannot revisit it. I must accept it as is.
That's the petitioner's position, is like that.
Yes. Anyone with a contrary view?
My Lord, very humbly, for that respondent, that interested party, sorry, I have only a challenge with your sentence that you must accept it. I think that should be qualified, my Lord, because that is a High Court like yourself, and our humble view is that that decision is not binding on you. My Lord, it's only persuasive, and that is what we'll also be submitting, my Lord, that that decision is not binding on you. My Lord, perhaps also to bring into context, I am aware that there is an appeal against that ruling. The Court of Appeal has certified that matter as urgent for hearing, and I believe the appellate court will be dealing with those issues more substantively.
Yes,
So, my Lord, to that extent,
Has it been stayed?
sorry, my Lord,
Has it been stayed?
not yet, my Lord, but directions have been issued certifying the application as urgent. So, my Lord, to the extent that it is persuasive, we have no problem. You cannot accept it wholesome without yourself digging into the whatever I can say the merits or demerits of that.
So you have stated, Council Kirimi, that you will also address this in your submission.
Yes, my Lord.
So I'm not making a determination.
If I may, my Lord,
Yes.
for the fifth interested party,
Yes.
the name is Meru.
Yes.
My Lord, on the part of the Assembly, because that ruling in Meru was between the petitioner and the County Assembly, which was the respondent in that matter.
Yes.
Our position is as follows, my Lord. Foremost, that ruling is not binding upon you. But even more fundamentally, my Lord,
Yes.
the petitioner has brought the question or the issue of whether there was a conservatory order stopping or halting the impeachment motion before you for determination.
Yes.
So to the extent that, my Lord, that issue is before you for determination, and parties have extensively submitted on that issue, parties have pleaded,
Yes.
we have replied, the County Assembly has replied a very detailed reply affidavit
Yes.
on the issue of whether there was a conservatory order.
Yes.
It remains a matter before you, and it is perfectly open for you, my Lord, because the petitioner brought it to court. It did not disclose that that issue was before the High Court in Meru.
Yes.
It is perfectly open for you, my Lord, to interrogate the pleadings that have been filed by parties, the submissions by the parties, and for you, my Lord, to arrive at your own independent decision as to the question of whether there was a conservatory order. It is a live matter that is before you, my Lord, and we will urge you to exercise your discretion on that question.
When your time is reached, you will submit on that with more breath.
Thank you, my Lord.
So, you may proceed.
Thank you. Just one comment so that the record doesn't capture that. Mr. Mawira says that the petitioner came here and didn't disclose to this court that there was a pending contempt of court application at Meru. The farthest an advocate can go from the truth is that submission. The farthest. Because the petitioner, in fact, attached the full contempt of court application in Meru as an annexure to the filings here. How clear can a disclosure get, my lord? I have been at the bar for the last 20 years. I can't imagine a clearer disclosure than actually photocopying the full contempt of court application and putting it before you as one of the annexures. And more importantly for me...
No, that's not how I do things. Let counsel finish his point.
I'm guided.
Yes, counsel.
Just for completeness of record, that application is to be found in volume number 9 of the documents before you at page number 64. At page number 64 onwards. Order number 2 is that the Speaker of the County Assembly of Meru, I. Bundi Solomon, the Clerk, Meru County Assembly, Jacob Kirari, and Zipporah Kenya, a nominated member, the condemned be cited for contempt of the orders of this court issued on 24th and 29th July 2024 by Justice Linus P. Kassan. It doesn't get clearer than that. Allow me to progress.
Just a moment, Councilor Ngwe. Yes, there was an interjection.
My lord, the interjection is the issue that the petitioner did not disclose is that the question of the conservatory order was pending in another court. It's not a question of contempt. It's the issue of whether the High Court in Meru, in this court, there's a possibility of these two courts arriving at conflicting decisions on the issue of conservatory order. That is the issue. It's not the issue of contempt.
Well, let me progress so that there's order.
Just a moment. Your time is not running.
Thank you.
So I will. This is an important link because there are certain consequences to the High Court making a finding of contempt, rather allowing a contempt application. Those facts, factual basis that led to that decision would then be resident. That is the uncontrovertible position. The High Court cannot speak on the same facts, same law, same circumstances. That is not what it does. So what I will invite those opposed, I will add a little bit more time so that you're able to canvass that point. Because I do not want, when I retire, for myself to call you back once you have that discussion. So we will have it extensive as to what is the application and import of that recently delivered ruling. You will appreciate, counsel, that it was delivered just about a week ago. So I could not call you or ask you to comment on it or to file supplementary submissions on it. So we'll have to do that. Councilor Ngwe, your time is back on.
Thank you, Madam. Before I progress, I noticed that when we took the quorum, the counsel for the second interested party was not present.
Yes.
Like I said, my learned colleague Eunice Lumala is present. It's really good perhaps that I put her on the record formally.
Thank you, Council.
Good afternoon, Council. How are you?
I'm fine, thank you.
It's not good afternoon, good morning.
Yeah, and apologies for coming in late. I was before an arbitral tribunal. Thank you.
Yes, Councilor Ngwe.
Thank you, my lord. I had already alluded to court that paragraphs 33 to paragraph 40 of that ruling, which is at pages 115 to 118 of volume number 10, are crucial. But I'll read them without asking the court to record that verbatim because the record is before the court. And this is what your brother, Justice Mureithi, observes. The court orders, as issued on 24th July 2024, were clear, halting in any way the impeachment process against the petitioner pending the court's delivery of its substantive ruling. However, the respondents on 30th July 2024 proceeded to withdraw the previous impeachment motion and pave way for the introduction of a fresh impeachment motion. However, The orders as issued on 24th July 2024 were still in existence and had not been vacated by the court on application by either party to the suit. The respondent acted in contempt of court by seeking to reintroduce a new motion of impeachment against the applicant. It is the old lesson in Hodkinson's case, Hodkinson versus Hodkinson, Volume 2, 1952, All England Law Reports at page 567, where Justices Somerville, Denning, and Roma taught yet again to obey all extant orders of court, held by Somerville and Roma Lord Justices that it was the unqualified obligation of every person against or in respect of whom an order had been made by a court of competent jurisdiction to obey it unless and until the order was discharged. I draw my court's attention to your brothers highlighting and underlining to add emphasis to the words unqualified and the words to obey it unless and until the order was discharged. Most unfortunately, the rule of law is still under threat close to a century later. Your brother has just made a finding that the County Assembly of Meru is a threat to the rule of law almost a century after the finding of Lord Justices Somerville.
Let's circle back.
Yes, my lord.
Let's circle back. I think it is the preceding paragraph.
Yes.
A large part of the defense by the respondent and also by the County Assembly is that the initial order applied to an initial motion,
Yes.
which was then withdrawn.
Yes.
And a new motion was filed, and that led us to today.
Yes.
That finding, dated 13 February 2025,
Yes.
appears to state,
Yes.
not appears, plainly states,
Yes.
that the act
Yes.
of withdrawal
Yes.
and refiling was itself an act.
Correct. Correct.
Just a moment.
Yes.
Just a moment.
Yes.
What is the fifth interested party's position on that? That's fine. The time was posed a long.
Lord, allow me to, first of all, on behalf of the sixth interested party, the mover of the two motions,
Yes.
to give a bit of context to that one. My Lord, first of all, introduction and withdrawal of motions in the Assembly is guided by the standing orders.
Just a moment. Just a moment. What I cannot do is I cannot sit in review of that. That decision is a decision of the High Court and the High Court judge. All I need us to agree upon is what is the import of it for the High Court. Can I look at a finding of contempt, because it is a finding of contempt, with respect to the second motion and this one? Just that. What is it?
My Lord, our view is that the ruling that my senior has talked about is with regard to the impeachment motion, the initial motion that was dated 15, and that was tabled on 17 July.
That is not what the ruling. That is what the ruling says. Oh, the ruling says the mere fact of withdrawing the initial motion and filing a fresh motion was itself an act. It's plainly said. You will not get another opportunity.
What is the question, my Lord?
What is the import? Does that bind you that that second motion was in contempt of court?
My Lord, for the fifth interested party,
Yes.
in response to your question, my Lord, the ruling of 13th, that when there's a finding that the act of withdrawal was in contempt of court, as a fifth interested party, my Lord, our position is as follows. Firstly,
Yes.
we will not be asking you, my Lord, to review that decision. by the High Court in Meru.
Yes.
We are not asking you to sit on appeal of that ruling, my lord. We are only saying that that ruling, my lord, is not binding upon you, because this matter is before you for determination. And perhaps, my lord, it might help that in our submissions and even in our replying affidavit,
Yes.
we contend that the petitioner has sustained 2 petitions, and that there are some aspects of this petition that are sub judice the petition in Meru. Such that, my lord, if our finding is made in Meru, the petitioner, by sustaining similar issues in these 2 petitions, is applying that decision here. And my lord, she cannot benefit from that mischief. And that is why, my lord, we are saying she has come to court with unclean hands. That the High Court in Meru is seized of some matters which are equally seized with, my lord. And this matter is now before you for determination, my lord. It's either the petitioner concedes that some of these issues are sub judice,
Yes.
or the court proceeds to determine these matters altogether, because these are matters that are before you for determination. Not on review and not on appeal.
Just a
Determine
moment.
them afresh. Yes, madam.
Just a moment. The reason why I am... Sorry, there's a hand up. I don't know whether that's...
Your Lord, Zipporah Kenya, the mover of the motion, and if I'm allowed, I can explain why I moved a second motion, and I can explain why I feel there were no court orders, if I'm allowed.
Yes, Madam Zipporah, first of all, good morning. How are you?
Good morning. Good morning.
You're represented by counsel. You were joined as an interested party separate from the assembly within which you serve. It should not be proper for me to open essentially a hearing by receiving comments from yourself. However, what you can do, you can whisper into your counsel's ear.
Yes, yes.
And stand down.
Yes, yes, yes. Yes.
Counsel, I stopped your time for 10 minutes, so I'll just add.
My lord, me.
Yes.
I was not done.
Oh, sorry, neither was I. Then I lost my train of thought. The reason I'm stressing this point is it is potentially determined that this entire, if indeed it has already been finding that the second motion was in contempt, and the High Court, sitting as this judge, cannot re-examine that, it would then potentially be determined in favor of one direction.
Indeed, my lord, I was not done addressing you.
Yes.
Perhaps my colleague, I'm appearing with Mr. Bayer. He can address you further.
Yes.
For the 5th interested person.
Yes, Mr. Bayer?
Good morning, my lord. My lord, for the record, my name is Bayer.
Yes, good morning.
Yes, this is a very critical issue because it refers to the same order. The only difference that she does is that the respondent in one case is the county assembly, and the respondent before your lordship is the speaker. Raise the same issue. She gets a ruling on none of the issues.
Yes.
And she expects to get probably a similar order before your lordship. She comes to the ruling before your lordship, and she tells you that these matters that are raised before your lordship should not be considered by your lordship, because the petition that you had filed early in Meru has already determined that issue. So you are now bound and you cannot proceed. That is what the petitioners are telling you.
Yeah.
It is a clear abuse of court process, my lord, because those issues which are before your lordship are some of the issues that the respondent and the interested parties have extensively submitted on. So the question before your lordship this morning is very simple. You have a petition before you which raises these very issues that you are bound to determine. But now the petitioner is telling you, no, don't determine them, even though you raised them before your lordship, for the simple reason that now you have a favorable ruling before from the High Court as well. And this is our contestation, my lord.
Yes.
The proper thing for you to do, the proper approach, before this honor of the court is to reconsider the petitioner's petition before the court on that issue and the responses filed by the respondent and the interested parties, and reach your own conclusion based on the petition that has been filed before your lordship. It is only that way, my lord, that justice in this case can be served. Alternatively, my lord, is for your lordship to reach a finding that the petitioner has acted with an unclean hand by sustaining two concurrent petitions before the same court in different stations, with the hope that in one of those court stations she will get a favorable outcome. And therefore, because she has acted with unclean hands, my lord, the proper thing for this court to do is to down its tools with regard to determining the allegation by the petitioner on that particular issue. Those are the only...
Counsel Fire, just a moment.
Yes, my lord.
Sorry for interjecting. That other matter was between the petitioner and the county assembly.
Yes, my lord.
Were you in that matter?
The court assembly was that matter.
Were these proceedings brought to the attention of my brother in there?
No, my lord.
Thank you. Mr. Ngoy?
Your Lordship, before Council takes over, I just want to...
Look, I've gotten enough. I've also placed you on notice that there's a potentially determinative decision of the High Court recently delivered. I think I've done what the law requires me to do. Councilor Ngoy, proceed. Unless...
If I may, my lord,
yes.
for the county assembly, just one minute. My lord, there's another potential danger, my lord,
Yes.
with treating that ruling as having settled that issue. Because for the very interested party, my lord, our position is that that ruling is per incuriam. That ruling was made without regard to the relevant law on contempt of court proceedings. And if it is treated, my lord,
It's a pending matter.
I'm getting, my lord, and that is why, my lord, I'm saying that if this court was to treat that ruling as determinative of that issue, and the Court of Appeal ultimately reverses that ruling, it will create a very untidy situation, my lord.
The law and precedent that guides judges requires a judge, when something has happened and parties perhaps have not had the opportunity to address it in their written submissions, the judge must bring it to the attention of the parties. I have done that. I am also required to get a feel of it, which I have done. I have also given you a very clear direction that when your time comes, I will add time so that you're able to canvass that
Very well, my lord.
extensively. Let the petitioner proceed.
Thank you. Well, for my law studies, I had interest in literature.
Yes.
Chinua Achebe taught me that an old woman feels very uncomfortable when dry bones are mentioned. So I'll proceed. At paragraph 35,
Yes.
the brother finds as follows, that it is immaterial that the clerk of the county assembly, the deponent of the respondent's replying affidavit, believed it to be inconceivable that the court granted the said orders without first determining whether it had jurisdiction, or it granted, quote unquote, a blanket order effectively shielding the petitioner from present and future impeachment processes. Judicial authority of the sovereign state of Kenya lies with the court, and the members of the county assembly could not validly second guess the orders of court. I emphasize the words, could not validly second guess the orders of court. I make a submission here that the second guessing of the orders of court has thereby been declared to be invalid when the court says it could not validly second guess the orders of court. It behoves them to seek the review, setting aside, or variation of the order, not to act in a manner contrary to the order merely because they believed it not conceivable that the order could have been issued by the court. Conclusion. Clearly, the respondents were in contempt of court. That's a definitive finding. To withdraw a notice of impeachment against which orders have been issued by a court, and to introduce a fresh impeachment process outside the one subject of a court proceedings in which the court has made injunctive relief, so as to defeat the effect of the court order, is similar to withdrawing a suit in which an order restraining certain conduct has been made, so as to defeat the said court order. It is a classical textbook case of disobedience of court orders, albeit in a crafty manner. It is gaming the system of the rule of law that binds the three arms of government in mutual respect of separation of power. My Lord, let me emphasize the fact that the gamers that the judge is referring to are the fourth interested party before you, and the sixth interested party, Zipporah Kenya. The court has described them in a formal ruling of court as gamers. With respect, the court did not purport or pretend to grant, as submitted by the respondents, immunity to the petitioner against the accountability mechanisms under Article 181 of the Constitution and Section 33 of the County Government Act. All the court did was to hold the status quo pending the inter partes hearing and determination of the serious dispute presented by the petitioner in her petition. When the respondents proceeded with the process of impeachment of the petitioner, despite and indeed in spite of those orders, the respondents were in clear and mitigated contempt of court. These are the findings of the High Court. The County Assembly of Meru was in clear and mitigated contempt of court. If it were permissible to withdraw cases in which adverse orders have been made to avoid having to comply with the orders, no case would ever be heard to conclusion, as the suit would be withdrawn by the unsuccessful plaintiff or the injurious act abandoned and fresh wrongful act commenced by the debarred defendant whenever orders adverse to the party are made, and the respondent who stood to benefit from the orders will lose confidence in the system of justice. It will be a clear case of subversion of the rule of law and sabotage of the justice system, which the court cannot countenance. Orders. Accordingly, for the reasons set out above, the court makes the following orders on the application dated 1st August 2024. Number one, the respondents were guilty of contempt of court, and the appropriate relief within the meaning of Article 23(3) of the Constitution in this case against the named members of the County Assembly of Meru is a declaration that the respondent is in contempt of court, which the court hereby grants. Of course, the court proceeded to punish them as permitted by law. To the factual question, was this in violation of the orders of court that were valid and in force? The petitioner's simple and straightforward answer is as follows. Yes. Why? Because a court of law has determined it. It is authoritatively determined by a court of competent jurisdiction that the fourth interested party, the fifth interested party, and the sixth interested party are contemnors of court, and that they instituted and undertook impeachment of the petitioner in contempt of court.
Yes.
The respondent is established under our Constitution as an institution of checks and balances. The Senate exists as an institution of checks and balances. It is not for fun that the framers of our Constitution made impeachment of governors a two-tier process. The County Assembly and at the Senate. It was to ensure that each of these institutions acts as checkmates. It has been demonstrated factually, my lord, that the respondent's attention was drawn to these orders of court, and the respondent chose to perpetuate, to compound that contempt. Leaving only one question for determination. In view of this clear and unambiguous contempt, what are the consequences? The answer is to be found in volume 10A, the case of Honorable Martin Nyaga Wambora and 4 others versus the Speaker of the Senate and 6 others. The same respondent before you, my lord.
Yes.
And it's very curious that 10 years, a decade before this contempt of court, a decade before this, the court had warned the respondent before you of the consequences of this kind of actions.
Yes.
At paragraph 281 and 282, the court will find the consequences of this action, and I quote, "We, however, find the reasoning in Clark and others versus Chadban and others, 1985, volume 1, OER, page 211, most attractive in this case. It was held, and I quote, an act done in willful disobedience of an injunctive or court order was not only contempt of court, but also an illegal and invalid act, which could not, therefore, effect any change in the rights and liabilities of others. I need not cite authority for the proposition that it is of high importance that the orders of courts should be obeyed. Willful disobedience may properly be described as being illegal. If by such disobedience the persons enjoined claim that they have validly effected some change in the rights and liabilities of others, as the respondent purported to effect change in the status of the petitioner before you as governor of Meru County, I cannot see why it should be said that although they are liable to penalties for contempt of court for doing what they did, which is what the court in Meru has done, nevertheless, those acts were validly done. But the legal consequences of what has to be done in breach of the law may plainly be very much affected by illegality. It seems to me, on principle, that those who defy a prohibition ought not to be able to claim that the fruits of their defiance are good and not tainted with illegality that produced them, even if the defendants thought that the injunction was properly obtained. Just as counsel for the interested parties have tried to tell you, they think that the order was improperly obtained, or too wide in its terms, that it provides no excuse for disobeying. The remedy is to vary or discharge it. We are in agreement with the above authorities to the effect that anything done in disobedience of court orders is null and void ab initio, and it is a nullity in law. Therefore, the 6th respondent, having proceeded to pass a resolution for the removal of the first petitioner from office in defiance of court order, means that the resolution was a nullity. It is like that the resolution was never passed in the first place. In the circumstances, there was no valid resolution which could have been forwarded to the Speaker of the Senate for action under Section 33(2) of the Act. The subsequent actions of the Senate are a nullity, including the decision to remove the first petitioner from office. These are the kind of cases, my lord, that council may pause and say are on all fours with the facts and the circumstances before you. In a proper system of legal practice, counsel for the respondent and the affected interested parties would by now have sought out the petitioner for an appropriate consent to settle this matter. But we are where we are. You have to do duty. In concluding on this question,
Yes.
we submit that the petition before you can very well be disposed of on that issue alone. That issue affects the entire petition, even without going to other process and merit review issues. I'll therefore take just the next 5 minutes to submit on the other two issues, then invite my learned colleague, Mr. Mutuma.
Yes.
On the question whether the Senate proceeded with matters that were sub judice, again, I'll just make a simple reference to volume 1A of the petitioner's document, in particular at page 342. That page is a continuation of the Hansard of the afternoon of 20th August 2024 before the Senate of Kenya. At the third last paragraph, the attention of the Senate was brought to the following facts. I said then, and I say now, that the second set of matters I want to deal with are
Just a moment. Yes, the second set of matters I want you to deal with.
the second set of matters I want to deal with are pending active litigation in court as we stand here today. What I will describe as matters that are sub judice. Count number 1, paragraph 1 of the impeachment motion alleges that the governor illegally revoked the appointment of CPA Virginia Kawira Miriti as the chief executive officer, CEO of the Meru County Public Service Board. Distinguished senators, it is not in dispute that this matter is pending active litigation at Meru Employment and Labor Relations Court, case number E002 of 2024, CPA Virginia Kawira Miriti versus the governor, Meru County. The governor invites the Senate to consider, as a matter of principle, what is its policy on matters sub judice? What is the policy of this Senate on matters that are pending active litigation before other courts of before other competent institutions of dispute resolution? My lord, factually, you will see that the issue was raised, the case in respect of which the pending matter was existing was drawn to the attention of the Senate, and therefore the Senate could not plead ignorance on having proceeded with that matter that was pending for a court of law. Evidence of the pendency of that case has been supplied in volume 2 of the governor's documents at page 14. Another matter that the governor wants you to apply the same mind on, matters that are actively pending in court, is what I referred to earlier as count 1, paragraph 4, on the alleged dismissal of Dr. Ntoiti, Paul Mwaki, Kenneth Mbaye, and Joseph Kithure Mberia. Madam Temporary Speaker, in addition to the fact that this is a matter that this Senate has already applied its mind on, Mr. Mutuma will submit on that issue, that this same fact involving these same people, involving this same transaction, had been a subject of impeachment in November 2023, and the governor had been acquitted of that fact. The same fact involving the same people, the same transaction, is brought to the Senate in August 2024, and the governor is convicted. Mr. Mutuma will deal with that aspect of this limb later on in our submissions. So I proceeded that it is not in dispute that this matter has been and continues to be in active litigation. This matter went to court as Meru Employment and Labor Relations Court Petition number 1 of 2022 and is now pending appeal. Evidence of the pendency of that appeal process is at page 71, volume 1B of the governor's documents. Again, my lord, the Senate had its attention specifically drawn to the pendency of this matter before a court of law. With tremendous humility, I invite this House to take this as a question of principle. What is the legal policy of this Senate on matters that are actively pending in our courts, such as paragraph 4, count number 1 of this impeachment motion? If you look at ground number 2, paragraph 6, and ground 3, paragraph 11 of the impeachment motion in the County Assembly's documents, volume 1, this matter relates to the case of one Daniel Mudiani alias Sniper and the contributions towards his family and the role connection of Kiambi Christmas Manyara as an accused person in that matter. The County Assembly at volume number 2 of its documents at page 429 has supplied this court with the charge sheet of that murder case. I beseech you, distinguished senators, to again make a principled decision in a matter such as this, where the County Assembly, by its own documents, admits that it is a matter pending active trial in our High Court. What is the policy of the Senate towards matters such as those? In summary, my lords, the Senate's attention was clearly drawn to matters sub judice. Standing Order number 103 of the Senate Standing Orders prohibits members from discussing matters in issue directly and substantially before a court of competent jurisdiction.
From discussing matters that
are in issue directly and substantially before a court of competent jurisdiction. That's the Senate's own standing orders. In our case, the respondent before you allowed discussion of these matters and resolution on these matters to the detriment of the petitioner, in violation of the Senate's own rules.
yes.
We urge that this motion is for allowing on that ground again. Finally, on the question of fair trial, the factual basis will come out later when we play the video clips. At the tail end of the Senate trial, the petitioner was entitled to address the Senate before a resolution was passed. The petitioner in person was allowed to stand and address the Senate before a resolution was passed. Senate then broke into pandemonium. The decision maker himself broke into pandemonium. There was complete disorder, as my lord will get from the Hansard that is before you. There was complete disorder. As a consequence, the Senate itself prevented the governor from addressing it out of its own pandemonium.
Yes.
If this court were to give me permission to address it as it has done now, then break into pandemonium itself. No involvement of the governor at all. The Senate itself, members of the Senate themselves. The video clips will show a very shameful development. At page 354 of the Hansard at volume 1A, you will see the Senate has a very interesting parliament generally by tradition. has an interesting way of calling noise. It calls noise loud consultations. So you will see multiple references to loud consultations. Just before the speaker calls Boni Halwale to be out of order, then you will see again loud consultations, then loud consultations. So you will notice that these multiple references to loud consultations progress on page 355. All these, my lord, are noisy sessions. It is Senate's own decorum of sanitizing its documents, out of tradition, we don't blame them, out of tradition for consumption of the outside world. This is the environment in which the governor was treated first. So she was denied a chance to be heard, which is entitled to by the rules of procedure involving impeachment in plenary. She is entitled to be heard. We urge that impeachment of the governor before the Senate constitutes a dispute that can be resolved by application of law within the meaning of Article 50 of the Constitution. That motion itself constitutes a dispute that can be resolved by application of law. And therefore, the petitioner was entitled to a fair hearing before the Senate, and denying her that opportunity to be heard by Senate's own breakdown of order violated her rights. On those three grounds, I'll be inviting this court to make a finding in favor of the petitioner and, in substance, quash the resolution of the Senate. Allow me to invite my learned colleague, Mr. Elias Mutuma, to carry on from there. My lord, perhaps we'll start by getting a time indication of how much time I've spent and how much time my learned colleague has, just for time management.
We were to stop at 1:15. We will now be stopping at 1:40. Remember, you have video that you said is about 40 minutes.
Yes.
And there's also a first interested party who would require about 10 minutes.
Thank you, Your Lordship. I will address you on the remaining three issues. My learned senior has done a good job, and therefore I will not go so far with the issue of the right to fair hearing, save for just giving you the constitutional background of the same. My main address to you, Your Lordship, will be on the constitutionality of Section 33(8) of the County Governments Act and how that provision of the law limits the right to fair hearing and contravenes the provisions of Article 50(2)(o) of the Constitution. My Lord, the petitioner has moved this court and has invoked three specific and exclusive jurisdictions as found under Article 165 of the Constitution.
Yes.
The first jurisdiction that has been invoked is for Your Lordship to exercise your original and exclusive jurisdiction to determine whether a fundamental right under the Bill of Rights has been denied, threatened, or violated. 165(3)(b). To that extent, Your Lordship, we will be demonstrating that the respondent in this instance violated the right to fair hearing. Second, and most importantly, Your Lordship, is that you've been invited to exercise your jurisdiction under Article 165(3)(d) to interpret the Constitution, in this case, Article 52(o), and how it sits with the provisions of Section 33(8) of the County Government Act.
Yes.
The last piece of jurisdiction that has been invoked, Your Lordship, is to exercise the jurisdiction and determine whether any act said to be done under the authority of this Constitution or any other law is inconsistent with the provisions of this Constitution.
Yes.
Your Lordship, the last aspect has been addressed comprehensively. That the respondent in this matter, Senate, purported to discharge or perform certain acts which did not have the backing of the law because the High Court in Meru had expressly barred that from happening.
Yes.
My Lord, since we are interested in looking at a determination on the question of whether a right was violated, allow me go quickly to Article 19 of the Constitution.
Yes.
Specifically 19.2, and this is what it states. The purpose of recognizing and protecting human rights and fundamental freedoms is to preserve the dignity of individuals and communities and to promote social justice and the realization of the potential of all human beings. 3, the rights and fundamental freedoms in the Bill of Rights belong to each individual and are not granted by the state. That is very important to me, Your Lordship. That the rights and freedoms under the Bill of Rights, they belong to each and every individual. They are not granted by the state, not the County Assembly of Meru, not the Senate, not even this court. We are born with those rights.
Yes.
I move to Article 20 on the application of the Bill of Rights. Under subclause 1, the Bill of Rights applies to all law and binds all state organs and all persons. There is a reason why, my Lord, I am emphasizing on all persons, every individual. And now 22 says, every person shall enjoy the rights and fundamental freedoms in the Bill of Rights to the greatest extent consistent with the nature of the rights or the fundamental freedom.
Yes.
Then the Constitution places an obligation upon you, Your Lordship, under subclause 3 of Article 20. In applying a provision of the Bill of Rights, a court
Yes.
in applying a provision of the Bill of Rights, a court shall, I jump to 3B, adopt an interpretation that most favors the enforcement of a right of fundamental freedom. 4, in interpreting the Bill of Rights, a court or tribunal or any other authority shall promote the values that underlie an open and democratic society based on human dignity, equality, equity, and freedom. My Lord, the reason why I've taken you through that journey is because when you look at the respondent's response alongside those of the interested parties opposed to this petition,
Yes.
I've argued that the petitioner cannot enjoy the rights under Article 50 2.0 of the Constitution. That is what they will stand to tell you. But my Lord, Article 19 and 20 talks about every person. The petitioner certainly is a person.
Yes.
The very specific article start by stating the following. My Lord, Article 50.0. It says, every 52.0, Your Lordship, every accused person has a right to a fair hearing, fair trial, sorry. Every accused person has a right to a fair trial, which includes, straight I jump to O, not to be tried for an offense in respect of an act or omission for which the accused person has previously been either acquitted or convicted of. In very clear and plain English. I urge your Lordship to apply a literal meaning to the application of Article 52.0. Now, the respondents, alongside the interested parties, will argue that the rights under Article 50 are only available to a person facing criminal charges, exclusively. In fact, the word they have used is purely in criminal matters. But my Lord, those are their words. I have combed through Article 50. I do not see any reference to criminal proceedings. Let's begin from where the article starts. Every person, Your Lordship.
Just a moment, Counsel.
Yes.
So that I understand your point.
Yes.
Just read the opening line of Article 50 close.
I'm there. That's actually where I was going, Your Lordship.
Yes.
That every person, starting from one. Yes. I'm beginning from one.
Not from one.
Yes.
From two.
Yes.
One is not.
Correct. Correct, Your Lordship.
Not in dispute.
Correct.
We all know how one applies.
Correct, Your Lordship. Every accused person has the right to a fair trial, which includes. The instructive words there is every accused person has a right to a fair trial. So the person to whom Article 50 applies, number one, must have been accused. Not in a criminal trial, because that is not in the Constitution, but he is standing in the position of an accused person. Has a right to a fair trial. Therefore, they must be facing a trial.
Yes.
So the question is, was the petitioner facing a trial? Was she standing in the position of an accused person? And the answer is yes. Your Lordship, there is a reason why Article 19 says that in your interpretation, you must give benefit to the person who alleges the right has been violated, so that they must enjoy that right to the greatest extent possible.
Yes.
There is a reason that's why that provision appears. My Lord, I have no time to go through the Hansard. But when you look at the mode of operation of the Senate, is that the governor, the petitioner in this case, is required, number one, to plead to the charges in person. If she pleads guilty, and guilty is a term that we all know is applicable in a criminal trial or even a quasi-criminal trial.
Just a moment. Yes, proceed.
But I refer you to volume 1A, and at page 11, all the way. Are you with me?
Yes. The charges against you as received from the County Assembly of Meru are
Correct.
as follows.
Yes.
Yes.
So the petitioner is required to plead. Charges are read to her. The particulars of the offense are read to her, and she is required to plead either guilty or not. Should she plead guilty, end of the case, she is convicted. A verdict is rendered. If she pleads not guilty, a trial commences. And what is the nature of this trial, Your Lordship? it is a replica of what transpires in a criminal setup, criminal proceeding setup. Complete with the prosecution on one side and defense on the other. Complete with examination in chief, cross-examination, and re-examination.
Yes.
So the literal and plain meaning of Article 52, Your Lordship, is that that right is available to a person who has been accused and a person facing trial. There is no doubt in our minds, Your Lordship, and there should not be any. Yes, Your Lordship.
Just so that I record this.
Yes.
Page 12, the clerk of the Senate, it's about the third, 1, 2, 3, 4, 5, 6 paragraphs from the bottom, just below Roman numeral 4.
Yes.
Please read that.
Yes. Honorable MWANGAZA, how do you plead to the three charges? Guilty or not guilty? The governor in response states, not guilty.
So it's the petitioner's submission that the Senate's use of that nomenclature invites Article 50, Clause 2.
Indeed, in that it
So if
presents.
a civil court
Yes.
used that nomenclature,
Yes.
would it then also apply?
My Lord, I was very clear from the beginning.
Yes.
Article 52 is not only applicable to a person facing criminal charges exclusively.
Let's look at Article 52, let's take H.
Yes, yes,
Article 50, Clause 2, Paragraph H.
yes.
Please read it out.
To have an advocate assigned to the accused person by the state and at state expense if substantial injustice would otherwise result, and to be informed of this right promptly.
Where does this occur?
This, Your Lordship, will occur in my experience of practice in murder cases. The state will provide counsel.
This right is read out in criminal proceedings.
Indeed, Your Lordship.
Alone.
My point is this, Your Lordship,
Yes.
that the application of Article 52 is both to criminal cases and any other person facing a trial who has been accused of certain violations and who has a personal consequence of the outcome.
Yes, please proceed.
Indeed, Your Lordship, inasmuch as you're seated in a civil matter today, if there is contempt of court, inasmuch as this court is not a criminal court conducting a criminal trial, it will invoke Article 50 in sentencing or in taking the necessary action against the contempt law. And that, like in the case of Meru. So it cannot then be said that Article 50 can only apply to people facing criminal trials. If the framers of the Constitution wanted Article 50 to purely apply to criminal cases, they would have said so in this provision.
Yes.
The choice of the words here, Your Lordship, is deliberate by the framers of the Constitution. And just to confirm that point, Your Lordship, when you go to Article 50, it says every person has a right to have any dispute that can be resolved by the application of the law decided in a fair and public hearing before a court, one, if appropriate, another independent and impartial tribunal or body. So it was clear in the mind of the framers that there are people who will be facing trials, not necessarily criminal, and they will need to enjoy the right to fair hearing.
So that I understand your submission, so some of the rights in Article 50 Clause 2 would necessarily be purely for criminal.
Absolutely.
Some would apply.
Absolutely, Your Lordship. But the fact that some purely apply to criminal does not take away the right of other people facing trial to enjoy those rights.
I've understood that.
Thank you, Your Lordship. Your Lordship, Article 24 and 25 of the Constitution. 25. I begin with 25, Your Lordship. I'm actually interested in 25. Despite any provision in this Constitution, the following rights and fundamental freedoms shall not be limited. Shall not be limited. One of those rights is the right to a fair trial. So when then the respondents argue and invite you to limit the right to fair trial of the petitioner as provided for under Article 50(2)(o), they are in essence inviting you to violate Article 25 of the Constitution.
Yes.
Therefore, Your Lordship, when Section 33(8) is enacted and purports to take away the right as expressly provided for under Article 52(o), then the provisions of Article 2 must kick in. The supremacy of this Constitution, Article 2 for any law, including customary law, that is inconsistent with this Constitution is void to the extent of the inconsistency. And any act or omission is in contravention of this Constitution, should be invalid. My Lord, we are in agreement that the Constitution is the supreme law of the land. It is the grand norm.
Yes.
Upon whom all other norms, including the County Governments Act, must derive their validity. Therefore, Section 33(8) must be declared unconstitutional by Your Lordship invoking your powers under Article 165 to declare it inconsistent with Article 52(o) of the Constitution. Why? Because it allows a person who has faced a trial, a person who has been either convicted or discharged, to face similar charges. And now I move to the factual issue of that argument, Your Lordship. Let's look at the charges that the petitioner was facing. Yes.
In the interest of time, because that is not in this.
Yes,
we can need to go so granular.
Thank you so much, Jello. And in any case, we have highlighted the similarity between the charges that were preferred against the governor in 2023 and those that were preferred against her in 2024. Most importantly, Your Lordship, there has not been a denial from the respondents that indeed some of the charges that were preferred in 2023 were the same charges based on the same evidence that were brought a year later. Surely, Your Lordship, there is a reason why the rule against double jeopardy exists. It is to prevent an abuse of the legal process, which is exactly what the County Assembly of Meru is doing. Taking advantage of an inconsistent section of section 33(8) to drag the petitioner in a court process, or rather in a trial process, even after she has been found not guilty of the charges. Having dispensed with that issue then, Your Lordship, allow me move to the right to fair trial as contravened by the respondents.
I believe you're now on 5, which is whether the threshold for the impeachment of the petitioner was in fact met.
Yes, Your Lordship, I'll address that as well. Your Lordship, we have already established that the right to fair trial is non-derogable. It cannot be limited. I also wish to submit, Your Lordship, that that right is continuous. Right from when charges are being drafted to when the final verdict is made. Again, Your Lordship, go back to Article 50. Article 50 says that every person has a right to have their dispute determined in a fair and public hearing before a court, or if appropriate, another independent and impartial tribunal or body. The words I want to capitalize on is impartial, independent. 2A, to also be presumed innocent until the contrary is proven. That's a right that cannot be taken away whatsoever by dint of Article 25 of the Constitution. So did the respondent then act independently? Did they exercise impartiality? Did they presume the petitioner innocent and await evidence to prove the contrary? Then the answer is an emphatic no. They did not do that.
Yes.
Your Lordship, an old saying states that when the alligator comes out of the water and tells you that the crocodile is sick, you must believe it. The alligator has come out of the water, Your Lordship, and has come to tell us what we did at the Senate was a sham, was a mockery. We were under pressure. We needed to do this and get away with it.
Yes.
Why should we not believe them? That question.
Yes.
Your Lordship, on the issue of presumption of innocence, if, Your Lordship, today we would find a draft copy of a judgment in respect of this matter in your file, would you be said to be impartial? Could you be said to be sitting here to determine this matter on merit? The answer again is no. Your Lordship, it is not in dispute, and I will not be able to go to the factual basis of that, that voting at the Senate took place. The first count,
Yes.
a vote was taken on 21st of August 2024. That is not in dispute.
Yes.
But before that resolution, Your Lordship, I want to refer you to volume 1B at page 610. I was in the Senate, the petitioner was in the Senate,
Yes.
and maybe my word does not mean anything But let's just look before, as you place your finger on 610, Your Lordship, I want you to kindly move to volume 1A, page 365. 367, sorry. With your finger at 610, let's proceed to 367, volume 1A.
Mine is my volume, you said 1A.
1A, yes, Your Lordship. So we have
367.
367.
Yes, I'm there.
We are in the Senate, Your Lordship,
Yes.
and the House is about to adjourn. And this is what the Speaker states. Honorable King, now you may be upstanding. Honorable Senators, there being no other business on the order paper, the Senate stands adjourned until Tuesday, 17 September 2024 at 2:30 p.m. Honorable Senators will be given priority to leave the chamber. Thereafter, the teams from the County Assembly and the Governor will follow, followed by the members of the public. The Senate rose at 1:09 a.m. on 21st of August 2024.
Yes, proceed.
But before that, Your Lordship, before the House adjourned, at 1:09 on 21st of August 2024, a communication had been done by the Clerk of the Senate. That is to be found at page 610, volume 1B. And this is what the communication states. First, it is addressed to the Clerk of the County Assembly of Meru, Mr. Jacob Kirari. Reference is decision of the Senate on the proposed removal from the office by impeachment of Honorable MWANGAZA, the Governor of Meru County. At its sitting held on 19th and 20th August 2024, the Senate, sitting in plenary, considered the proposed removal from the office by impeachment of Honorable MWANGAZA, the Governor of Meru County, and found the following particulars of the allegations against the Governor to have been substantiated. The three grounds are listed. Pursuant to the provisions of the Standing Order 48.2, I hereby transmit a message by the Speaker of the Senate conveying the decision of the Senate to the County Assembly. We will demonstrate through video evidence that the last count was voted on 21st of August 2024 at 12:55.
Yes.
And I'm referring, Your Lordship, to BK M9, which appears on the same volume, page 639.
Yes.
You will come across protests by a number of senators who absconded the votes. And Your Lordship, at page 642, this is a protest letter by 15 senators who are present.
Yes.
And it says, at 12:55 a.m., we register our protestation under Standing Order 91-1B, as we were denied the right to debate. Of importance, this document,
The page number.
642, Your Lordship, of volume 1B. 642 of volume 1B.
My 642 is not a letter.
It's a form, rather, Your Lordship, beginning with now, therefore, pursuant to Article.
Yes, yes.
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 My apologies. It's not a letter, you're right, Your Lordship. But let's look at the handwritten bit.
Yes.
It begins by a timestamp. It's at 12:55 a.m.
Yes.
In fact, better still, Your Lordship, because this document was pulled directly from the system. On the top right, there is a timestamp, in case anyone argues that this was concocted. And I can clearly see 2024 08/21 at 00:43 hours. This is the Senate's own system.
Your Lordship,
I have not come across.
Yes.
Your Lordship,
Here, that objection.
just for the record,
Yes.
we object to that document in its entirety, but I feel it will be better to address it at the opportune time when we are responding to the issues raised.
I'm fairly certain with that case management in this matter, quite a lengthy case management. When did you become aware of Volume 1D, Council?
Your Lordship,
When was it served on?
Your Lordship, the amended petition was served on 30th of December. 3rd January. Yes.
I'll reserve that objection. I've heard the objection. We will canvass it during the time.
Thank you, Your Lordship. In any case, just to address that issue, Your Lordship, nothing prevented the respondent, who is the custodian of this very document, to produce a document to counter what we have produced. Nothing. They have the originals, they have them in their custody. I would have expected counsel to produce a counter document, say it is not 00:43 hours. That has not been done. That benefit must be given to the petitioner, Your Lordship.
So that I'm clear, what turns on the time?
Your Lordship, what turns on the time is this.
Yes.
The communication by the clerk and the speaker of the Senate
Yes.
had a predetermined decision that was prepared, drafted, and signed in anticipation of the outcome.
Yes.
Because the only way you date a letter, you date the letter on the day you're working on it. We left chambers at 1:09. The last voting took place at 00:55. How could the speaker have communicated a decision that had not been arrived at hours before it was arrived at?
So the letter by the clerk is dated 20th.
Correct.
The voting takes place shortly after midnight on the 21st.
Yes.
Yes.
So, to that extent, Your Lordship, we cannot then argue that there was a presumption of innocence as required of Article 52A of the Constitution. There was a predetermined decision. On the last issue, Your Lordship, of what, as I say, I have less than 40 minutes.
Yes.
Your Lordship, it is our submission that the environment prevailing at the time,
Yes.
just before the voting, was such that it could not allow. Your Lordship, with your permission, can my assistant approach
Yes. Yes.
that desk?
I think this is a good point for us to watch
Thank you.
the video.
So I need not say much, Your Lordship, but we will witness chaos, anarchy, violence, shouting at the tail end, making it virtually impossible for any meaningful determination to take place. Your Lordship, as they sort out the technical bit,
Yes.
not only did the clerk and the speaker communicate to the county assembly of a decision that was yet to be made, but the speaker equally sent for publication of the resolution of the Senate hours before the determination was made. And it is for that reason that we are arguing that that Gazette notice itself, which is dated 20th of August 2024, but published on 21st, was prepared in anticipation of the resolutions by the Speaker.
Your Lordship,
Yes.
just for the record, we are also objecting to that, but we will submit on it at length. The video, actually the video is Your Lordship.
The nature of an objection to a video should come before it is played. So let me hear your objection.
Your Lordship,
Yes.
first of all,
I hope my time is frozen, Your Lordship.
Yes, it is. Thank you. Yes, you may have the objection.
Your Lordship, first of all, when this petition was filed, just from the facts of the case, a certificate of electronic evidence was sworn by one Maingi Brian Muridi.
Yes.
That certificate, it's actually an affidavit, Your Lordship. It was dated the 21st day of August 2024. Your Lordship, subsequently you gave leave for the petitioner to file an amended petition together with any other documents that they wish to rely upon for purposes of that petition, Your Lordship. Now, Your Lordship, subsequently we were served with the amended petition together with all the documents that they seek to rely on. Then, Your Lordship, when I was going through the documents, I found out, or rather I discovered, that there's some discrepancies in terms of the certificate of production of electronic evidence, Your Lordship. These I raised in my submissions, Your Lordship. My submissions are dated the 11th of February 2025, Your Lordship.
What is the discrepancy?
Now, Your Lordship, the first discrepancy was, particularly for the videos marked, and I will list them, Your Lordship. For the videos marked BKM6, BKM7, KM7 and BKM9, KM10,
Sorry, KM, the first KM.
KM7 and BKM9, KM10 and VKM1, Your Lordship. I raised the issue, Your Lordship, in my submissions that the certificate produced therewith is defective and not compliant with Section 106 of the Evidence Act. The section, Your Lordship, gives clear details, or clear provisions of what a certificate should contain, including the evidence that they seek to rely upon, Your Lordship. Now, Your Lordship, subsequently, after my submissions, on Tuesday, Your Lordship, I am served with another certificate by the same Brian Maingi Muridhi. And Your Lordship, this certificate is in essence attempting to cure the issues I have raised in the submissions, Your Lordship. Your Lordship can confirm from CTS when that certificate was filed. That was on Tuesday, Your Lordship. So, Your Lordship, at the very least, even just from the factual basis, without even going into everything, there needs to be a reciprocity between colleagues in the profession. We cannot operate like this, Your Lordship. I can't file submissions raising issues, and you simply serve me with a certificate, and you say that is enough. So then, the videos that are sought to be produced, in fact, Your Lordship, the ones that have been added are in red, and I'm referring to the certificate by Brian Muridhi. The same is dated 27th January, Your Lordship, and equally, Your Lordship, that certificate was served on Tuesday, but is backdated to 27th January, Your Lordship. And it was served on Tuesday. So then what is the fate of my submissions on this issue? Because a certificate is just produced and you're told, yeah, that is enough. Equally, Your Lordship, in these videos...
Yes.
What is your response?
I let my senior address you on that.
Sorry, my Lord.
Just a moment. Let's take it limb by limb. Yes, Councilman.
Yes, my Lord, what section 106 of the Evidence Act requires is that video evidence be accompanied by a certificate.
Yes.
So be supported by a certificate.
Yes.
My Lord, I don't know it to be the law. As a matter of principle, even going with the fact that the law, I don't know it to be the law that the certificate must be filed at the time of filing the video evidence. I don't know that to be the law. Indeed, my Lord, even if no certificate had been filed,
Yes.
there is no prohibition in law for the petitioner to supply that certificate now in court. There's no prohibition in law.
Yes.
As I understand it, the purpose of the certificate is to authenticate the video. The purpose of the certificate is to authenticate the video. So that without going into the other minor facts of when filed, because I need to cross-check with our filing team now to get those minor details, as a matter of fact, on principle, Council does not dispute that as we seek to play these videos today, there is a certificate authenticating that. So in view of that, in principle, I don't understand what substantive law has been violated in view of the concession that as we seek to play these videos now, there is a certificate backing each of the videos that we seek to play. There are other issues. Council referred to BKM as some of the videos. We have no videos under that label. We only have videos under KM7, KM10, and BKM1. So when you refer to, I had referred to BKM, those were just documentary annexures. So we're also trying to cross-check our documents just to confirm that there was no error in the branding, and I confirmed that there are no certificates under BKM. The first three.
What is the source of these three videos?
They are set out in the certificate as the various websites are set out in the certificate. The Senate's own website. The Senate's own website. The Senate's own website.
Your Lordship, I beg to differ. Particularly KM10 is from a YouTube video from a channel known as Kenya News Alert TV. How is that a Senate video?
left my laptop. Someone have a copy of these, of the two certificates? Not be printed in my bag.
And if you look at volume number 9, at page 85 to page 89, is the certificate dated 27th January 2025. That's number 1.
Your Lordship, I can spare your time. I have both certificates here.
That's thank you. While at it, again, the court will take judicial notice of the fact that our parliament has a parliamentary broadcasting unit. To my knowledge, and since counsel is with parliament, he can verify this fact if the contrary, is that broadcasts from parliament come through the parliamentary broadcasting unit. That's the primary source of all broadcasts of parliament.
Yes.
And number 3, and more importantly, if there was any material discrepancy in the content of the video, material, substantive discrepancy, since the parliamentary broadcasting unit under the control of the respondent is the primary broadcaster and primary repository of all these broadcasts, nothing was easier than then to bring us another video showing that here is the authentic video from the unit and here is how.
Just a moment, Councilor.
Yes.
Just a moment. Is there a challenge to the authenticity of the video?
Your Lordship, particularly the video on VKM10, which is and maybe that's not the one they are going to play, but Your Lordship, I don't know if I should keep objecting to the videos as they go or I just raise them all.
Well, let's sort this out. This junction. I don't have a VKM referred to in the affidavit that you handed. Sorry, the certificate you handed.
Oh, sorry.
The one dated 27th January 2025.
Your Lordship, sorry, it's KM10. KM10.
VKM1, KM10, yes.
Yes.
What is wrong with KM10?
Your Lordship, this video is from an unknown account called Kenya News Alerts TV, Your Lordship. Even if I don't give another video to controvert that, Your Lordship, who is Kenya News Alerts TV? Can we call them here and cross-examine them about where they got this content, Your Lordship? It just is the law, or should we ask counsel?
So your objection is for KM10. You have a problem with VM1 and KM7?
Yes, Your Lordship.
So I've had you on KM10, VKM1.
Your Lordship, this one was not even accessible. Let's even begin at the basic. It was not accessible, Your Lordship. VKM1. So we are here, we are playing videos, Your Lordship, like VK1, M1. I have not seen the video. I don't even know which best the approach to go about it, Your Lordship.
Let's watch the videos first.
My Lord,
Yes.
I just needed to contribute briefly on this and just help us move forward.
Yes.
By saying that counsel is very lucky because he's practicing when we have the 2010 Constitution.
Yes.
And what he's raising is what Article 159(2)(c) came to protect us against. Unnecessary and procedural objections on technicalities when the authenticity of the documents and the videos are not in question. If counsel was served by the petitioners in December or early January, what stopped him from sending any requests or saying, counsel, my video is not starting. So basically, let's proceed so that he's given an opportunity to submit on those videos when they are being seen. Otherwise, let's not bring in technicalities that don't go to the substance of this matter. Thank you.
Let's watch the videos. Let's begin
I
with...
think you've got us out. We had an objection to the issue of the videos.
Yes.
A different limb altogether from what Mr. Mukele has raised.
Yes.
And if you allow me, Your Lordship,
Yes.
We took directions on the 18th of December on how we shall proceed today.
Yes.
Those directions were very categorical. We shall proceed by way of highlighting submissions.
Yes.
My Lord, I'm at pains to find a section in the Evidence Act that says that during highlighting of submissions, you can play videos. To my understanding, Your Lordship, that amounts to adducing evidence. It amounts to calling a witness to speak to the video, so that then we can test the veracity and authenticity of that particular evidence that is being portrayed in the video. My Lord, that was not the intention that we had when we gave directions on the 18th of December as to how we shall proceed today. My Lord, as if that is not enough.
And so on that point?
Just very briefly, we are proceeding on affidavit evidence. The affidavits have annexures. Where the annexures are written texts, like the Hansards and the letters, we read out as we have been doing. Where the annexures are videos, how else do you access videos? You see them. The contrary is more unjust. The contrary is where we don't play these videos, but because it's evidence, the court goes and plays them without the benefit of the party's comment or observation. That would be more unjust even to the respondents. I mean, how would they see it completely? So, the playing of these videos is just a reference to the contents of the affidavit. The affidavit says, on this day there was pandemonium, evidence of that pandemonium is in this video. So we are not going outside affidavit evidence. We're actually just referring to the material in the affidavit evidence. My Lord, please plead with our learned colleagues to allow us to proceed with this hearing. We know why they fear these videos, we have no doubt about it, but it's in the nature of a trial. Some parts of a case are just unfavorable to you, and you live with it. You can't run away from it. Please allow us to proceed with the hearing.
My Lord, if I may clarify an issue before the court, I was just on the issue of Section 106B of the Evidence Act and admissibility of the video there. My Lord, I refer you to the case of Republic versus Marisa Y. Mantugunda. My Lord, it's a 2011 case which interprets Section 106B and how parties should comply with the same. My Lord, the court said very clearly that this provision makes it abundantly clear that for electronic evidence to be deemed admissible, it must be accompanied by a certificate in terms of Section 106B. The question for the court, my Lord, is whether that evidence was accompanied by that certificate of electronic record. The petitioner has admitted that it was not accompanied by the same. They only filed it after it was raised by the Speaker of the Senate. It follows therefore, my Lord, it cannot be admitted before the court. It is tried by ambush, and the same thing should be struck out from the record.
Sorry, my Lord, it's not my nature to do this. The counsel have misled you in the authority he just cited a short while ago. because he read a part of it and the authority says the contrary.
Yes.
Paragraph 30 of that authority, the court says, I am alive to the fact that the applicants are not fighting the contents of the document, but the lack of the certificate. I agree with the learned trial magistrate that it's in the interest of justice that the respondents be allowed to produce the certificate at that time in the trial, and for the court to deal with the evidence on its merits. The objection by the applicant is therefore overruled and the application dismissed. This instance shows that an objection like theirs was overruled and the party seeking to produce the certificate allowed to produce it. How can counsel cite an authority partially, particularly where it's not supplied in advance? Counsel has a strong ethical duty when citing an authority extempore to be extremely candid. Otherwise, the authority my learned colleague has referred to at paragraphs 30 to 31 of the ruling of your sister, sorry, my apologies, Justice Mumbua Timatheka, which is the one she's referring to, I thought, says the exact opposite conclusion of the one he's inviting this court to find. That's revision number E006 of 2021. To the extent that's not the one, then there is authority to that effect. George Gabriel Gekuru and another versus Republic, where the court allowed a certificate on the day of the hearing and allowed the evidence to be referred to because there is no substantive contest on the content of the evidence.
My Lord, I'm not sure whether counsel got the data referring to. The event is the Republic versus Barisa, why you want to do it. It's a 2011 case, my Lord. And the court concludes as follows. In fact, the court concludes that this provision makes it abundantly clear that for electronic evidence to be deemed admissible, it must be accompanied by certificates in terms of section 106B. Without the required certificate, this CD, which was a CD in that case, is inadmissible as evidence, and I do know the same. And the decision is by Justice Odell, my Lord.
And my Lord, to respond to what my senior counsel raised about them being allowed to produce that certificate. Now,
Yes.
the meaning of the word accompany is ordinarily that those two must be brought at the same time, concurrently. And my Lord, the issue here is not even mostly about that certificate. It is also about the accuracy and veracity of those videos, because we do not have the source of the videos. We do not have anybody we can cross-examine on the occurrences of those videos. For all we know, they could be AI generated. They could be deepfakes. The internet has advanced recently, my Lord, and it's possible to do those things. There is no affidavit that is accompanying those videos. Therefore, there's no person we can put on the stand and cross-examine on the veracity and accuracy of those videos.
Let me give my short ruling on that. Counsel for the petitioner has conceded that the playing of the videos today would allow comment and observation by the parties. I agree with Counsel Kirimi in that regard, that it would blur the distinction between hearing and highlighting of written submissions. Counsel Mukele and Counsel Mwaria have, on the limb of objection on electronic certificates, have stated this is canvassed in their respective written submissions. Consequently, 1, the videos shall not be played today at highlighting, and the court shall view the videos through the stated links that are given in the petitioner's affidavits and certificates of production of electronic evidence. 2, the question of certificates shall be canvassed in the judgment as the certificates have been produced and we are past the hearing stage, and there is no question being raised to authenticity substantively. The objections are in the opposing parties' written submissions. If the objections in the submission succeed, the court shall determine as much and not rely on videos. Parties are reminded that in addition to producing evidence, there is material in the public realm on this issue. That's 21st February 2025. I've read the affidavit and I've read the written submissions. I understand, and I'm sure the opposing parties understand the direction that the videos being played today will have gone. The challenge is if you're opposing something that is already in the public realm, it's canvassed on news reports, the judge may say, that's fine, I strike out the videos, but the judge cannot erase what the judge read in newspapers and saw. So that issue is dealt with, unless someone wants to raise another objection.
My Lord, not another objection, but in your ruling that you've just given, you have said that no objection has been raised to the authenticity.
You cannot say authenticity is we do not know. You cannot prove, you cannot assert the negative. You have to say this is AI generated because we ran it through software and it said this is AI generated content. We have very many publicly available software. It cannot be enough for you to say I don't know if it is authentic, therefore it should not be submitted.
We are guided, my Lord, but we hope our objection has been registered on the same.
Counsel. Counsel, please rise. Please rise. Counsel, which video is inauthentic? So that I record which video is.
Your Lordship, we contend that all of them are inauthentic.
Why?
Because we cannot test the veracity of those videos.
If you cannot test the veracity of the videos on the 21st of February for documents that were filed well back, what is the court supposed to do, counsel? You should have taken these links, you should have tested them, run them through freely available software. You cannot say you want to reserve something that you cannot prove.
Your Lordship, it's a law that a party that makes a certain assertion should prove it. It's the duty of the petitioner.
Prove your assertion that this could be AI generated.
And it is also the duty of the petitioner to provide reliable and authentic evidence.
You cannot say that something is inauthentic because you have not confirmed whether or not it is authentic. The certificate is supposed to give you the opportunity to then dispel the contentions that are being made. I will not record a reservation because I cannot see a reservation.
Your Lordship, I think we're in agreement, me and you. It's just...
The practice as a petitioner, you should object to something when it is being produced as an exhibit. Not even marked for identification, when it is then being produced as an exhibit. Because the party may elect never to produce it, so it would not be an exhibit. In civil trials, particularly in the way we have canvassed this petition, the moment we went beyond here, then whatever is on record is on record. Sadly, highlighting of written submissions is not the time for challenge. So the videos will not be played. I will access the links. If there's a link that is not working, as has been stated by one of the counsel opposing, then, and please don't change the links because you can't change it. And I'm savvy enough to see if I look at the upload date and the upload date is different. If the upload date is after the filing of this certificate, then we have a very, very big problem. So please don't tamper with this. We were at the last Meru.
Yes, sir. Most obliged, Your Lordship. Perhaps I may also want to point out that the respondent is the custodian of the website.
I will consider that in the...
Yes.
Let's not have any more on that. I'll consider it in the...
Thank you, Lordship. In the absence of the videos, Your Lordship, allow me submit, like I started by saying, that when the alligator comes out of the water and tells you that the crocodile is sick, then you must believe it, because it lives.
Yes, Counsel?
Because the alligator lives in the same habitation with the crocodile. We have no reason to doubt it. The evidence that I'm about to rely on, say for the videos, are evidences of the judges. In this case, the senators, admitting themselves that what they did on the 19th and 20th and 21st of August
Yes.
was a mockery of the process. Why would we doubt them, Your Lordship? That would be the essence of video KM10, which will come across, Your Lordship. Senators in agreement that what they did in the MWANGAZA impeachment process did not meet the threshold.
I don't want us to reopen the videos.
Yes.
You have filed the Hansard, where in discussing another impeachment, some senators.
On that, we did not attach the Hansard, Your Lordship. We requested for it, but it never came in time. And by that time,
I'm sure I've seen it in the file. I've seen it.
Your Lordship, all Hansards are available online.
most of that then I must admit. But yes, we just, the only problem with the Hansards, Your Lordship, like my learned senior was trying to explain, where we have chaos, the Hansards will report loud consultations. So if you do not have the benefit of the video, loud consultations translate to something else. And that was the essence of us producing those videos. So that
just so that I think I'll have to read it again.
yes.
The videos shall not be played today at highlighting. The court shall view the videos through the stated links that are given in the petitioner's affidavits and certificates of production. So I will view these. It's not fatal to your case that you are not having it today.
Thank you, Your Lordship. Your Lordship, at page 614 of volume 1B,
Yes.
you will come across not a reporting, not just a newspaper cutting, but not just an opinion, but it is one of the judges telling the public through a newspaper of wide circulation of what transpired in the Senate. Senator Ledama Olekina. This is a person who sat as a judge.
Just a moment.
Yes.
For the reasons that I will record, this judge will not be able to consider that specific piece at page 614 court. The judge informs the parties that the author of the piece reproduced at page 614 of the petitioner's volume 1B was related to this judge by way of marriage and has been a long time family associate, having been written in his individual capacity, it would not be proper for this judge meant on saying unless the petitioner's case is essentially reliant on this court requests that the judge be permitted not to consider page 614 and only page 614.
Thank you, Your Lordship.
Any objection?
No objection, Your Lordship.
Anything from the respondent, interested parties? Any objection?
My Lord, we thank you for that guidance.
Yes.
But even going beyond that, there is no affidavit from...
It's a newspaper, that's it.
Absolutely. My Lord, for that document to be admissible, we would have expected, and for that document to have property value, we would have expected them to have an affidavit from the person, from the senator, for it to be of use to this court.
Well, it's now much ado about nothing, because I will literally, with your
Indeed,
permission, I will literally fold it and we will staple it when we go back to my chambers. I would have cut it out, but the law requires me to preserve it the way it is. I can't be commenting on my brother-in-law's.
Thank you, Your Lordship. Luckily for the petitioner,
Yes.
there were 60 more judges sitting in Senate. And Senator Ledama was not the only judge that came out of the water to tell us that the crocodile was sick. At page 613 of volume 1B, you will come across another judge by the name Senator Karen Nyamu in our official Facebook, and if given time, we can actually demonstrate.
I looked at this in chambers. I have already made up my mind. Facebook, when we say social media posts are tricky for us as courts. You must authenticate that it is that actual person, not a parody.
Very well, Your Lordship. Allow me then.
So court finds that the petitioner was not satisfied requirements on proving the authorship and authenticity of the social media posts on page 613 of volume 1B. The same are struck out. Yes, please proceed.
I see my learned counsel.
My Lord, we have another objection.
Yes.
My Lord, we thank you for the guidance that you just issued on the issue of the social media post.
Yes.
My Lord, we bring to your attention that the petitioners, what in essence they are doing, they are actually reciting the answered property. And my learned friend is actually naming names: Honorable Senator Leda Mukina, Honorable Karen Nyamu as judges. And my Lord, we urge this court to treat all that as hearsay. As we see it, my Lord, there is no affidavit. They are telling you the judges are saying, the judge Karen Nyamu is saying, but there is no affidavit to authenticate that whether indeed that's their position on this matter as we are in court.
Councillor, I must confess, I'm a bit at a loss. I've struck it out, so there's nothing more I can do other than that. That would be the ultimate benefit you gain. What more would you like me to do in 6:30?
That's okay for now.
Thank you. Yes, Councillor?
Your Lordship, I then swiftly move to the last limb of my submissions, that is on the issue of public participation. I need not rehash.
Yes, and as you're doing that,
Yes.
as you're on your feet, perhaps your colleagues were seated, and just confirm if the Hansard House was addressing another impeachment proceeding, and then referenced this proceeding. Please confirm if it
Lordship. Take you through the importance and the application of public participation as envisaged under Article 10 of our Constitution. Allow me just go straight to the sham, the mockery that is purported to be the public participation that took place in the county of Meru that is related to the impeachment of the governor.
Yes.
Your Lordship, just to ensure that my learned friends will not object to the validity of this report,
Yes.
it is their own report. It is not my report, and it has been annexed by the fifth interested party, the County Assembly of Meru, as JK-41E,
JK-41
41 in brackets E of their replying affidavit.
dated.
Uh,
Replying affidavit, please.
I will get it shortly, Your Lordship.
It's all right. I'll read that. Yes, please proceed.
Yes, as we get the date of the affidavit, Your Lordship, I will invite you to straight away look at pages, volume 4, pages 2071. It is the one dated 16th January 2025. I have found the date.
16th January 2025. You're saying volume 4?
Volume 4. I'm interested in looking at pages 2071, and we compare that to page 2076.
2071
Yes, 2071
of your volume 4.
of, yes, we have labeled it as volume 4.
Mine ends at page 1385.
It is the fifth interested parties.
Oh, the fifth interested party.
Correct.
Now, if we had brought all the hard copies, my writing space would have been non-existent. Could we request that the fifth IP perhaps lends us their copy?
So, we have the soft copies of all the filings, so that if you can just play it on the screen. The filings were served in soft copy, so we have the volumes at your soft copy. You can display them on the screen for ease of movement.
Now, if you have to log in, my able Mr. Gui will have to log in.
My assistant is capable of doing that.
The time it will take.
Yes.
No one has a volume.
But,
Can we
Your
just
Lordship,
have a
I can lend you mine, because I
I'm
know
not taking
that.
it permanently. I just
Yes,
need to
yes.
refresh.
I can lend you mine, Your Lordship.
Just need to refresh my mind as to what it was.
There's another one. Yes, Your Lordship,
Have a quick look. Page.
page 2071.
Perhaps, my lord,
Yes.
before we get back to that page,
Yes.
I have an objection.
Yes.
My lord, the rule in Anarita Kalimanjaro position in the petition, the petitioner ought to have set out with precision the particulars in support of that allegation. My Lord, if you check the petition itself, no particulars have been provided. If you check the supporting affidavit, paragraph 19, the petitioner says that the evidence in support of the allegation of fabricated evidence of public participation is a 1344-page document. That is KM6A and B of the petitioner's annexed list. A whole 1344-page document. No precision on where the specific allegation is followed. And if indeed the allegation is that the entire public participation report is fabricated, then, my Lord, they should take us page by page through that entire 1344-page document to show the evidence of this fabrication. The only attempt, my Lord, at providing the particulars.
Just a moment. So that I understand, you're objecting to the fifth interested parties.
No, I'm objecting to the page that where the petitioner is leading, page 2021.
In the fifth interested parties.
In the fifth interested parties document. The only pages they have provided, and it is in their submissions, my Lord, not in the pleadings, are pages 2357.
If I sustain your objection, what then becomes of those pages?
Well, the point I'm making is this. The only particulars they have provided in support of the allegation of fabricated evidence are 4 pages.
Counsel, you have the opportunity. Today is highlighting provision submissions.
Yes, madam.
You have your opportunity to water down their case or completely defeat it. What you have stated is not, to my mind, the nature of objection. You are submitting that they have not met a drafting rule on precision and then an evidential part. That you can take.
My Lord, my objection is this, my Lord, that we are getting the particulars in support of the allegation for the first time now. It is trial by ambush. They should have, in their petition, pleaded with precision the pages of this entire document that they purport are fabricated. Without that, my Lord, the fifth interested party will not wander around this entire document trying to discern what the petitioner complains is fabricated evidence. It is that simple.
Okay, let me get their point. I can see where you're coming from. Let me get their point, then I'll know. Yes.
I'm trying to find out what Mr. Maura is saying. That by referring to their own document, they are hearing of the contents of their own document for the first time now. I must concede sometimes I was lawyer and my lord, but for a counsel to stand at the bar and suggest that referring to his own document is trial by ambush, I may require clarification as to what ambush means.
Counsel, as I stated earlier, I'm struggling because if I sustain your objection, then the only thing I can do is strike out to those pages.
My Lord, my request is not that you strike out those pages. Those pages are indeed, the pages they have put in their submissions are indeed in my bundle of documents, that is Annex K41E.
Yes.
My objection is very simple, my Lord, that they ought to have provided the particulars of this fabricated evidence of public participation, whether in their annex, because this JK41E is the same as Annex KM6A and B in their document.
So what we should do, because you've stated the 3 ingredients. 1, that it is already in their submissions. 2, that it's in your documents, it's in an opposing side's document. And 3, it's also been responded to in your notice. I recall reading that they've not particularized. So is that really the nature of an objection, or is it you're arguing your side of the case before?
My Lord, it is the nature of an objection, my Lord, and I try to persuade you, my Lord, because what the petitioner has done, and in fact their petition they say that they will provide the particulars at the hearing. My lord, in petitions, they ought to have told us, I am complaining about a specific page, which I say is a forgery, so that I am able to respond. My lord, if, and I know as a matter of fact, my lord, that they say that some of the people who are in those meetings, who are recorded in the minutes, did not attend those meetings, my lord. The prejudice on the part of the assembly is that even if I wanted to call a person to depose an affidavit to say that indeed I was present in that meeting, I would not be able to do so because I don't know.
Okay,
it is which meeting, in which one.
Let me frame it differently for you.
Yes.
So I can see where you're coming from. Counsel Ngoya or any other counsel with specificity. Sorry, that word just never goes easily off my tongue. Could you point the court to where you have made an allegation of public participation not meeting the required threshold, being whatever it is that you are alleging within an affidavit or within the petition, and then cross-reference it to what else? Counsel, have I put words in your mouth without it was it?
Indeed, my lord.
Indeed, I've put words in your mouth.
Indeed, Your Lordship, we will direct you to the specific assertion.
Yes.
My team is trying to retrieve that, but also allow me to explain this, Your Lordship.
Okay.
The volume 5 that we're talking about, as correctly stated by the fifth interested party,
There's no number of recordings.
yes,
Still to get that close.
is a 3,000 plus page document. So even if we wanted to highlight each and every anomaly, we could not.
Did you cite any anomaly?
Yes, we did, Your Lordship. And we actually expressly said that we will then direct the court to the specific pages during the highlighting.
My lord, if you check the petition, the only place where they have mentioned public participation is the paragraph 36. And in fact, no particulars are provided. They are posing a question to the court. And this is what they are saying, my lord. That the question is, the standard and mode of public participation that ought to be attained to support an impeachment motion against a democratically elected governor in the face of a motion that relies on fabricated evidence of public participation. That is the only mention in the petition, my lord. No specificity.
I think I was clear. So I need it to be mentioned in the petition, then mentioned one of the, so that it's evidence. And then you can go into other things.
Your Lordship, I will direct you to our further submissions at volume 9.
Let's find it in as if it's stated as an affidavit.
Just allow us some time, Your Lordship.
So I think it is a good time for us now to begin discussing one or two things. We are at 1 minute to 2. By my watch, because I stopped time, you had 13 minutes left. And then 10 minutes for the first interested parties, or rather the interested parties in support. That would take us to around, let's call it 2:30. How then do we proceed after that to 2:30?
My Lord, with your kind permission,
Yes.
I had not been allocated time on behalf of the second interested party.
So I could give you 10. That would then take us to 2:33. Let's call it 2:35.
That's okay, thank you.
Are we going to break for lunch or are we going to go? Yes. So Sorry, may I have your name again? May I make a suggestion? Can we reconvene let's take a 20-minute break. That will then be in substitution to lunch. And we come back at 2:20. Everyone just grab a quick cup of tea. We will continue from where we left.
But before we go, may I just start? But, you know, objections are coming very fast, and you can see the documents we have. So it takes a bit of time to trace material.
Yes.
What is sure is that every issue we have submitted on is available in our filings.
Yes. I'm
So-
not determined the objection.
Yes, correct.
What I've said is, let's take this, let's call it half an hour.
Correct. When I come back, I'll address on that
Half an hour.
issue of the particular
And grab
regulation.
a quick bite, as well as find that, and then we see whether the objection is sustained or it's over. Is that fine? Yes, I'll see you all at 2:30 sharp.
Don't let us, the consultant out.